Welcome back to the final segment of this law session relating to contract law of frustration. Now, just before the break, I flagged up the cases of Chandler and Webster and also the Fibrosa, but I hardly did justice to it. So if we just go back for a moment there, looking at frustrating events, I did go through the facts of Chandler and Webster, which was along the lines of the Crellin Henry and Hearn Bay shipping type cases. But the idea behind Chandler and Webster is that it did provoke a fair bit of judicial criticism and was eventually overruled to some extent in the Fibrosa, the same case that I had raised earlier in relation to the war. But in respect of this particular point, I want to consider the facts of the Fibrosa in relation to those points. Well, in the Fibrosa, the respondents, as we knew, contracted with the appellants, who were a Polish company, to manufacture certain machinery and to deliver it to Poland. Now, part of the price was to be paid in advance, and the appellants had paid £1,000. The contract was frustrated by the occupation of Poland by German forces in 1939, and the appellants requested the return of their £1,000. Now, if you remember, we discussed this earlier as it relates to one of the reasons that a contract will be frustrated. Now, frustration was found in the facts because, of course, it would have been illegal to trade with the enemy. For our purposes now, what happens to the money? Well, the request for their monies to come back to them, the request was refused on the basis that considerable work had already been done on the machinery. Now, clearly, if Chandler and Webster had been followed, then the £1,000 would have been irrecoverable because it had already been paid at the time of the frustrating event. However, the House of Lords considered the matter, and they said that the appellants could recover their £1,000. The basis for this was not the contract, which had ceased to exist, but an action in what is known as quasi-contract for the restitution of money paid where there had been a total failure of consideration. So the courts looked at it from the standpoint of nothing had been given. By the time they had gotten to the point where the machinery should have come, you're looking at the German occupation. So the court said that they could get their money back. Consideration in quasi-contract does not have the same meaning as the consideration necessary for the formation of contract. So, if the party paying the money has received no part of the performance for which he bargained, so none of the machinery had been delivered, there is a total failure of consideration. So the position was improved but was still unsatisfactory for two reasons. The party who had to return the prepayment might themselves have incurred expenses but would be entitled to nothing, as in the Fibrosa. Because what if you'd bought various things in order to make this machinery, for example? Now, if the party seeking to recover the prepayment had received any part of what he bargained for, no matter how small, so let's say 1% of the machinery in the Fibrosa, there would be no total failure of consideration. So it would have been bad on both sides, because the idea is the return of the money was because of total failure. What if you had a 1%? Then that would not be total failure. What if the other side had bought something? Well, an attempt to deal with these difficulties, of course, led to the enactment of the Law Reform Frustrated Contracts Act in 1943. And what we get is that the act comes in to mitigate, for the most part, those kind of situations where we see that there's going to be a clear problem in circumstances where either there is no total failure of consideration, or the other party has already expended monies and need to give back to the party who has not gotten any consideration whatsoever. Well, first off, there are certain types of contracts which are exempt from the Law Reform Frustrated Contracts Act of 1943. So it doesn't include charter parties, for example. It doesn't include contracts of insurance. It doesn't include contract for sale of specific goods, and contracts where the parties have made their own provisions as to what is to happen in the case of frustration. So In modern times, it is the 1943 Act which must be applied to ascertain the position of the parties upon the occurrence of frustration and not the common law, unless, of course, the contract falls within any of the exempted categories I've mentioned. Now, the point, of course, is, again, if we take this to an exam scenario, once you have determined whether or not there is frustration, and let's say that your submission takes it along the point of saying that there is frustration, or even if you're saying, well, based on my discussion, arguably there is no frustration. However, in the event there had been, this is where, for example, it would fall. And then, of course, it gives you a chance to be able to respond to the examiner's question. Remember, the entire idea about the exam is that it's there for you to show the examiner what you know, not to tell him what he does. It's two different things, and law students most of the times tend to be telling the examiner what he does know and to teach him the law. Rather, you need to show him what you know by saying, well, in the event that there is no frustration, of course, under the Frustration Law Reform Frustrated Contracts Act, this is what would happen. But that said, Section 1.2 says, money paid or payable prior to the frustration. Section 1.2 deals with that. And Section 1.2 says that all sums paid or payable before the frustrating event shall be recoverable or cease to be payable. But that said, the court does have a discretion to allow the payee to set off against sums so paid or payable expenses which have been incurred by him for the purposes of the contract, and that makes it a lot fairer. So if I've contracted with you to use your music hall and you've gone out and you've had it painted up in a particular color specifically for my use, you may be able to offset that expense from any deposit I've paid you, but given the frustration, you still have to give me back my money, albeit that there may be a set-off under Section 1.2. Well, under Section 1.3, it says compensation would be paid for a valuable benefit. And Section 1.3 provides that where one party has obtained a valuable benefit, the other party may recover from that valuable benefit such sums as the court considers just. Now, this takes into account a two-stage process. First, it seeks to identify and put a valuation on the valuable benefit which will set the upper limit of any just sum award. And the second point is, of course, there is a calculation of the just sum. Now, if we look at the first part, the identification and the valuation of the valuable benefit, this is very difficult and somewhat controversial. For if we take a case like Appleby and Myers, which we touched on earlier, there are two alternative arguments. The first is that no valuable benefit had been obtained because the completed work has been totally destroyed. This was the one where he had built the building and everything got burnt up. Or, secondly, on a more liberal interpretation, that a valuable benefit was obtained by the owner in that work had been done on his land as per the contract immediately before the discharge. Now, it may be that in an Appleby and Myers situation, the second interpretation is preferable in that the Act does speak of a valuable benefit being obtained before the time of discharge, and the owner is more likely to be insured against fire than the builder. However, even with a liberal interpretation of the Act, this wouldn't cover all situations. Example, the Krell and Henry type situation would not be able to claim. Krell there would not be able to claim that he had conferred a valuable benefit upon Henry by arranging to have his furniture stored away whilst Henry was in the flat. Now, Section 1.3 was considered by Justice Goff, whose judgment was affirmed by the Court of Appeal and the House of Lords in BP Exploration and Hunt number 2 in 1982. Hunt, who owned an oil concession in Libya, contracted for its development with BP Exploration. Now, BP were to provide the capital and the expertise, and if and when the oil was developed and sold, BP would be paid back from Hunt's share of the oil. After BP had done considerable work and incurred great expense in developing the oil field successfully, the Libyan government withdrew the concession and the contract was frustrated. Now, BP claimed under Section 1.3, the House of Lords, affirming the judgment of Justice Gough, held that BP had incurred expenditure under the contract and consequently a valuable benefit had been conferred upon Hunt in the form of the increased value in his share of the concession. Now, the second point, of course, is the calculation of this just sum. And the second stage is for the court to assess what sum, not exceeding the value of the benefit, it considers just to award, if anything. Now, in accordance with Section 1.3, it must consider any sum received by the plaintiff under Section 1.2, again, if there was any, and the circumstances giving rise to the frustration of the contract, so the position after the frustrating event. So, for example, in Appleby and Myers, the fact that the owner's valuable benefit no longer exists. The party then can look to Section 1.3 to the extent of £9,000 if he was deemed to have conferred a valuable benefit from Y immediately before the discharge. Now, that is a massive if there was a valuable benefit. Now, the court will take account of the destruction of the machinery, still using the Appleby case, in the calculation of the just sum. Now, Section 1.2 does not apply because there's no prepayment. So you have to look at the sections carefully because, of course, it means that you have to look at whether Section 1 applies insofar as trying to get a benefit under Section 1.3. Now, what about the perishing of the specific goods? Well, Section 7 of the Sale of Goods Act 1979 provides that where there is an agreement to sell specific goods and subsequently the goods, without any fault on the part of the seller or the buyer, perish before the risk passes to the buyer, the agreement is thereby avoided. Now, the section applies only to specific goods and will operate, therefore, in cases where the property passes under certain rules, specifically, of course, Section 18 of the Sale of Goods Act. Now, the consequences of frustration, when you look at Section 7 of SOGA, are set out, of course, in the cases that arise from that. Now, the Law Reform Frustrated Contracts Act is not applicable in certain cases. Now, if both parties, so if you're looking at cases where the act is not applicable, both parties are discharged from the contractual obligation, or where the price or part has been paid, it can be recovered on a total failure of consideration, or on a total failure of consideration, the seller cannot deduct anything for expenses incurred before the frustrating event occurred, and payment also made under a contract cannot be recovered if there is only a partial failure of consideration. Now, case in point, as we said, we looked at Cutter and Powell earlier, and we see where, for example, in Cutter and Powell, it was an entire contract, and the courts, of course, said that nothing would have been payable. Now, when you look at a case like that, when you look in light of the Law Reform Frustrated Contracts Act, you may certainly see a tempering and easing of the way the common law was before, and certainly as it relates to what can be recovered, the Act appears to offer a great deal of redress in that regard. Now, this, of course, brings us to the end of the session on frustration, and certainly I would ask you to join us for all the remaining sessions of contract law. But at this moment, that brings us to the end of this session.